All right. A big ADA ruling came down today. It's June 12th, 2025, regarding the Americans with Disabilities Act and the Rehabilitation Act and what that means to schools. And generally what it means is parents that sue or families that sue for discriminatory reasons based on the Americans with Disabilities Act are going to win more lawsuits. Their standard of proof has lowered. So let me break down standards of proof for a little bit for those of you that are not, more accustomed to legal stuff, right? And yeah, I've been a practicing lawyer for 26 years, so I can probably, I say practicing. I've been a licensed attorney for 26 years. I haven't practiced in a while, but I think I can probably handle some legal standards of proof. All right, so let's talk about it in criminal law context because I think we're most familiar with that. We watch Law and Order and all these crime shows. So we have the highest level of proof that for a prosecutor to convict and put somebody in jail. It's called beyond a reasonable doubt. So not just a reasonable doubt. You can't just have a reasonable doubt. Beyond any reasonable doubt, whatever that means. But it means you don't have any reasonable doubt and you convict somebody. Well, why do we have like that high level of proof, which by the way is not in every country? Well, the way it was presented to me in law school was we would rather have 4 guilty people go free than 1 innocent person be convicted. So we need to be sure before we convict somebody and take away their freedom, put them in a jail, that they really actually did this beyond any reasonable doubt. So that's a very high level of proof. And now you can argue it doesn't always work, but that's the highest level. Right underneath that level, you've got this standard called clear and convincing. Now, I know that it doesn't tell you you're 80% sure or you're 70% sure, but clear and convincing to me has always been floating somewhere, in the 75% range where beyond a reasonable doubt is it could differ for different people, 95% sure, 99% sure, right? Clear and convincing is you're really convinced, but you may have a little bit of doubt. All right. The next level beneath that is preponderance of the evidence. Preponderance, I always took to mean just over 50%. So if you're more likely to believe that they did it than they didn't do it, then they're convicted, right? And then you have these 2 lower levels, which is really what it takes to arrest somebody and detain them, which is you have to have probable cause a crime was committed or reasonable suspicion a crime was committed. Not reasonable suspicion that they look guilty, but reasonable suspicion an actual crime was committed. So much lower levels, and it kind of works your way up before you get convicted. Now, let's turn to civil law, right? Because this is civil, this isn't criminal, but I thought that might help kind of frame it. So in this case, the Americans with Disabilities Act, to win a lawsuit, it required the person claiming discrimination to say that the schools had actual bad faith in their actions. They discriminated and they had bad faith in doing it. It wasn't just an accident. They had bad faith. They meant to do it. Well, now unanimously, that means all the Supreme Court justices said, we're going to lower that standard to deliberate indifference. So you don't have to have bad faith anymore, which is kind of tough to prove that somebody's, they actually kind of intended bad things, right? Now it's just, you were just indifferent. You were deliberately didn't even care whether or not bad things happened to this child with a disability. You were indifferent to it. Now it still has the word deliberate in front of it. So you were still deliberately didn't care. Now, it wasn't like you accidentally didn't care. You have to show that deliberate intended. So that's still not, just an accident. So we didn't lower the standard down to you accidentally discriminated. You still had to be deliberately indifferent, but it's much less than bad faith. So, hopefully that made a little bit of sense. So let's get into what are the actual outcomes? How will this look in real life, right? So I pulled up a couple old lawsuits that were filed under the Americans with Disabilities Act. And so Ava Tharp's, Tharpe, if you want to look it up, she had a case where she was an epileptic and she needed to go because of her epilepsy to take evening classes. This was a Minnesota case. And a judge, lower level judge, found that the school district violated the IDEA, but the district appealed it. So they went to the higher level of court because they said, we don't like that ruling. And that's pretty normal. And the higher court dismissed her claims. But that means she lost because her lawyers did not prove that the district actually had bad faith in not allowing the evening classes. Now, what would happen today under this new level? Well, it's more likely that she would have won. She may have even won because they've lowered that standard. She doesn't have to prove bad faith anymore. She just has to prove they didn't care, like in deliberate indifference. So she may have won that case. Now, in a case out of Tennessee, a student during graduation was forced to sit in the audience and placed in a closet classroom separate, and which seems like discrimination, right? Now, this case is ongoing, so I don't know whether or not they're going to use the new standard or the old standard. I guess they're going to use the new standard. It's ongoing right now, so I think we ought to pay attention to this. This is Tennessee, Kennedy Lee case in Tennessee, so if you want to look that up. And so this new standard is certainly going to strengthen her position, right? Now, there was a case in 2017, and it was a denial of a service dog, right? And I know service dogs have become all the rage on airlines. Everybody's got I got lots of dogs. I really do. I really have lots of dogs. I think we're getting a new cat this weekend for my daughter. And so, like, I believe in having animals, man, but yeah, is it really a service dog or is it just a dog you want to hang out with? And, I don't know. But in this particular case, in 2017, a student named, last name Fry, was denied access to school with her service dog. Now, she won because the family reached a settlement that allowed her to graduate with her dog. Now, future cases, though, are going to be more successful under this standard. And here's the last case I kind of want to hit, which was, this was out of Michigan, Paris versus Sturgis. A deaf student went through school for years, it says, for years, with a qualified interpreter, and only received, in their words, poor training aids, right? Well, they settled the lawsuit, and the family reached an agreement, but the case helped clarify that the ADA lawsuits can proceed even after resolution, right? So what does this mean? It means with the new deliberate indifference standards, a lot of these lawsuits are going to kind of skip some legal hurdles. And I think that without digging in too much, and basically there's a little bit of a legal hurdle, like a technicality, you might call it, that could have stopped this person, but the families end up settling. Well, the families are going to settle for more, or they're going to be able to skip this hurdle now because of this lower standard. So the basic gist is you're going to have, I don't know if you'll have more lawsuits. Sometimes when standards lower, lawyers recognize that and file more lawsuits. So you could end up with more lawsuits if you're school, so get ready for it. And the standard's lower, so you're going to end up paying out more. Right? So, I know you don't want to discriminate, but just watch your P's and Q's and don't, right? So, but I got to get into this. Does this apply to private schools, right? I know I've been on a tirade recently about the difference in voucher programs between private and public schools. And now public schools fall under Title II. I'm not going to get too nuance, but I just want you to know there's a difference. Title II of the Americans with Disabilities Act. Now, this applies to all government-run entities. It's pretty tough. This includes all public K-12 schools, and it does include charter schools and public universities. So charter schools, same boat, public schools, public universities. Title II requires accessibility and non-discrimination. And those are two very big different things under the Americans with Disabilities Act, okay? So the Americans with Disabilities Act has these two gigantic components. One is access, and like wheelchair ramps and things like that, to give everyone equal access to get into places of public use, right? And then this other section, it says no discrimination either. All right, so that's good. Now, private schools fall under Title III of the Americans with Disabilities Act. Now, this applies to places of public accommodation. Now, so private schools, private colleges, test centers, daycare centers, things like that are all considered public. So the schools have got to comply with the accessibility rules. So they have to make reasonable accommodations to make sure people can get in and out and all those great things. But Title III does not require the same procedural safeguards, the same protections as Title II does. So back to my theme this year, I guess, is we treat these institutions differently. We have different rules for them. Now, I should say as a caveat, there is a section 504 of the Rehabilitation Act that applies to any school receiving any federal financial assistance, public or private. Now, somebody's going to say, well, that means if they get a voucher that they're obligated to go. No. you got to look at Section 504. Section 504 applies to federal financial assistance, not state, not local, not county. Now, a lot of states have very similar laws as Americans with Disabilities Act. And so you have to look into every individual state. People got questions, want me to do a state run on this. I'm more than happy to, but sometimes the state laws are a little bit different. And sometimes they just mirror image the federal one. But as far as the federal Americans with Disabilities Act, only if the institution receives federal financial assistance. So that does get me into this new big, beautiful bill and the voucher assistance that may cover. So if anybody takes anything of that, the Americans with Disabilities Act, Title II and Title III should apply. So I think we got to keep an eye on that. So, just to kind of summarize this, the legal bar has dropped nationally. This means more families will have the power to sue when schools, potentially fall short, but they are more likely to win also. All right, let's keep going.